Good evening, ladies and gentlemen. Welcome to Intersect's monthly training session. My name is Leigh Maingard. I'm the Director or Chief Operating Officer of Intersect Sectional Title Services. We do a training session every month and we invite all our clients to join us. Just some protocol. Everybody is on mute. So if you do have a comment to make during the training session, you're more than welcome to put it in the chat box, if we call it like that. And when we finish with the training session, we'll have a look at the questions and we'll work through that and see if we can answer them for you. The training session is only an hour, so we won't take more than that time, 60 minutes. So this evening, we are talking about quite an interesting subject. It's about working from home in sectional title schemes. And with me this evening, we've got Oren Freitas dos Santos. Oren is from the Advisory Community Scheme Specialist. They are attorneys who specialize in sectional title and homeowner association matters. And we've had Oren before. Oren, thank you. It's nice to have you with us this evening.
Thanks for having us, Lee. Appreciate it.
Thank you very much. So we look forward to getting Oren's insights into the subject matter this evening. So let's jump straight into it. Working from home in sectional title schemes. Ever so much we get a situation where an owner or maybe the trustees will contact us and ask us what are the situations or when can somebody work from home. I think going back to when was it, 2020 and during COVID, obviously pretty much everybody worked from home unless you were essential services. I think some people got some certificates just to kind of get out of home or out of the house and get outside. But I think a lot of people got used to working from home, and I don't really think at that stage it was really a big thing. Maybe Oren, just to jump in here from the start, your recollection of COVID. I mean, I'll be very surprised if there were any issues from body corporates or owners with regards to that. I mean, obviously it was an international scenario, but I
Yeah.
don't think. I mean, I don't think anything. I mean, obviously it changed since, but your experience in that from a legal perspective in
Yes.
during COVID.
I think that the experience during COVID and the lessons learned out of that are going to be quite useful to frame the takeaways from this session. And that is the distinction between a home occupation, sorry, a home, let's call it the practicing of an occupation at home and the conducting of an enterprise from home.
Yeah.
So we know during COVID that there was no movement permitted. So everyone was sitting in front of a laptop, working from home, no people coming in or out as part of that occupation or business. And that's going to be the takeaway, I believe, from this meeting is the distinction between practicing an occupation and conducting a business where there are, in fact, where there is movement involved. But yes, from a COVID point of view, no, we didn't receive any inquiries or complaints about that practice. What we did receive a lot, and I'm sure you did too, is the use of common property during lockdown. But thank goodness we don't have to ever talk about that again. Hopefully, fingers crossed.
Well, hopefully, yeah,
So
certainly.
yeah.
Yeah, thanks for that. All right, so what we're going to do tonight, we're going to go through. So we have some items to discuss. It's certainly not very long, but I think it's pretty relevant to the session this evening. So we're going to obviously just try to understand what sectional title living is. Very simple. Then we're going to have a quick look at working from home versus running a home-based business. I think probably that's Oren, that's probably what you were referring to. What's the distinction between working from home versus running a home-based business? And I think in that lies a lot of the issues that can possibly clear any kind of gray areas in this regard. We're going to have a look at the legal framework, the Sectional Title Schemes Management Act, municipal zoning bylaws, which is most important in this scenario, permissible scenarios and non-permissible scenarios. So we will quickly look at what kind of businesses are permissible, and then what the consequences are if you're non-compliant. So by default, if you're saying consequence of non-compliance, also means that you need to be compliant if you want to have a business, or operate a business from home. So we're going to look at that, and then steps to ensure compliance, and then we'll have a conclusion. So we might not be the full 60 minutes, but we'll work through this and get Oren's insights into this.
Sorry, Leigh, before we continue, Shane, poor Mohammed is crying for help desperately in the chat. So if someone from your team can perhaps help him there before we go any further.
I cannot hear anything. Is it good? Can anybody else hear? No voice on my end. I cannot hear anything. Is there anybody else maybe that's got the same problem? I can hear. Okay, so everybody else, Mohammed. Okay, so you can't see anything. So
yeah,
let me just yeah. So it must be on his side.
Yeah, it must be on his device.
It must be on his device.
I'll type a message to him while you continue there, just to tell him to leave and come back and check his settings, so you can
probably
continue.
Just do that. Perfect. Thanks, Oren. Appreciate that. All right. So understanding sectional title living. So we're certainly not going to go through the entire understanding of sectional title living. There's the Sectional Title Schemes Management Act. There's the prescribed management rules, the prescribed conduct rules. But what is the concept of sectional title living? It's a form of property ownership where individuals own sections or units, if you want to, and share common property. So there's also the saying that as an owner in a sectional title scheme, you own an undivided share of the common property. It doesn't mean that the common property is yours. You can do whatever you want to. Hence the laws or the rules of a body corporate. Sometimes those rules are not amended. Sometimes they are. And mostly when they are amended, the trustees or the owners amend them to be relevant to their scheme. So no scheme is obviously ever the same as the other one. So it really depends on each scheme owners, the owners and the trustees, how they want to amend their rules if that's what they want to do. And then the governing laws for sectional title living, Sectional Title Schemes Management Act, as we mentioned, or in the industry, talk about the STSMA. We've got the prescribed management rules, and then we also got the conduct rules, and then very important, the municipal zoning bylaws. All right, so working from home versus running a home-based business. Working from home, what would be, I wouldn't say a definition, but the understanding of a working from home scenario is performing a job duties remotely, for example, online work. Being a consultant, possibly being an attorney, being someone in a professional side, but not necessarily seeing people or coming to their apartment on a daily basis or a frequency that's obviously not acceptable. So, and hence the second point, minimal impact on the property and neighbors. So you can understand that if somebody's working online, like we're doing now, we're having an online kind of training session. And I've got earphones in my ears, and those people at home are just sitting there listening to what we're talking about, and you can comment on what we're saying. So that will obviously have a minimal impact on the property as a whole. And when we talk about the property, we talk about the entire scheme, access to the scheme, people moving around, and mostly that is one of the biggest concerns. Maybe, Oren, if you can come in here. Well, I think one of the biggest concerns really, even if you do have an online working scenario for somebody working from home, is the frequency of people coming to the complex and nobody knowing who that person is. And obviously this security comes to mind. I mean, security is then a big risk. And then simple things, wear and tear, the gates are open more often than what they normally are, or the vehicle access gates are open if you've got parking around.
So that's definitely the distinction between working from home and a home-based business. Working from home is effectively a one-man job, right? So
Mm.
it's when no other persons are expected to be present for you to conduct your operations, whereas a home-based business carries with it the inherent need for other persons or products for that matter.
Mm.
So staff coming in and out, clients coming in and out, or deliveries coming in and out. Where if
Yeah.
what's important, you might not have people coming in and out, but you might be operating an online business, and there is couriers coming to your front door 7, 8 times a day. That
Mm.
then changes that distinction from working from home as a sole person into a home-based business because
Yeah.
the strain on the body corporate's common property is increased and the disruptions are increased as well.
Mm. Yeah, I think maybe just to add to this, and I'm just thinking about a scenario that we have in a scheme that we manage where, and as you know, the rules of the prescribed rules states that the body corporate or the trustees as the body corporate effectively and the managing agent must have the details of the tenant, which in this case in this scenario we did obtain, but then kind of finding out that the tenant, who isn't even the owner, the tenant is running some kind of I'm going to call it a business because we still haven't really established what's going on there, with a person coming in and out on a daily basis, frequenting the premises, parking in a parking bay that's dedicated to the apartment, but nobody has any idea of who this person is. And the body corporate, obviously via the managing agent, is trying to establish exactly who this person is. And the biggest concern for the trustees and other owners are obviously, who is this person? They don't live here, they're not renting there, but they're in and out the building. And I think that becomes quite a big problem. And especially when the information that you're asking for is not forthcoming from the owner, because the owner is the person that the body corporate through the manager agent deals with.
Yeah, and in that regard, one has to be reminded of one of the duties imposed on an owner in terms of Section 13(1)(f) of the Sectional Title Schemes Management Act, which requires them to notify the body corporate immediately of
Mm.
any change of ownership, which is obviously not applicable, or occupancy in his or her section.
Mm.
Now, this person appears to be occupying the unit, whether it be for temporary periods, but or permanently, but there's definitely some form of occupation taking place. So the owner has to somehow find out who this person is so that he can relay that information to the body corporate. It's the owner's duty at the end of the day to get that information to the BC.
Yeah. Yeah, and this is where obviously the problem is that we're struggling to get that information.
Yeah.
I want to maybe just pose this question to you, Aaron. In connection with working from home, right? So we're looking at it says duties remotely, but for instance, a professional like let's say a psychologist, obviously they see people on a regular basis. I mean, where would you put that kind of um, job description, if you want to call it that? Where would you place that in terms of working from home? Where it's a professional, it's not a high impact on on neighbors necessarily, but on the property, yes, and the people coming in and out all the time. Again, would you look at the application to the body corporate to allow that
Mhm.
to make sure it's compliant? Because obviously we're going to get to that, but that is quite an important part of this
Yeah.
entire process.
So what we will see when we get to the point is that whether it is a working from home scenario or a home-based business scenario, some form of consent will be
Mm.
required from the body corporate, and I'll explain in a minute when we get there what
Yeah.
that means. So either way, there's consent required. Now it's about determining what type of consent is required, and to me, the yardstick is whether or not the operation of this enterprise changes or at least increases the amount of traffic in and out of the
Mm.
scheme, the use of common property parking, and has an effect on the security of the scheme. So if I take your example, of the psychologist, if he or she offers online consultations with their clients, that's obviously a working from home scenario. There's no in and outs of people, but if they have the odd client coming into the gate and out of the gate,
Yeah,
that then changes the nature of it to a home-based business
correct.
based on
Yeah.
that criteria.
It's almost like you've got both sides of the coin there.
Mm.
Because you're going to have traffic increase in traffic, not necessarily noise, but the traffic issue is going to be probably problematic.
Correct.
So the home-based business, opposite of working from home, operating a business from the residence, for example, a salon or consultancy. Consultancy being could potentially be, like I said, a psychologist, for instance, and then looking at the potential for increased traffic, noise, and other disturbances. So it's a pretty easy way to probably look at it. But as we go along, we'll see that the opportunity to have both of those kind of operations in a scheme is potentially there. Right, so the legal framework, STSMA, the Sectional Title Schemes Management Act, Section 13(1)(g). Owners must not use this section for purposes other than those shown on the sectional title plan without written consent from all owners. And I think the important part there is with written consent from all owners. So, Orion, I mean, how easy or how difficult, let me ask it, put it that way, how difficult is it to get the consent from all owners? Because we know how difficult it is to get the most basic things sometimes approved for
Yeah.
some other reason.
Yes. Yeah. So the written consent of all owners, what makes that tricky is that silence doesn't deem consent. So you would have to actually receive written consent from owners. You can't send out a notice, and if they don't respond, accept it as approved. So if you're dealing with a scheme of 30 or 300 owners, I mean, you can imagine the legwork in making sure that each person submits their written consent. Of people have their day jobs and their lives and things to get on with. It's not going to be easily responded to. But in a smaller scheme, it's obviously much easier to manage. But the minute you, I think, get past about 10 owners, then it becomes quite tricky in a scheme. So it's very difficult in practice to get the written consent of all owners.
Yeah. Playing devil's advocate, I mean, on the basis of that, what you've said, and obviously us being in the industry, knowing the practical implications of that to achieve that, would you say that there are more people than not running a business from their apartment than what there is allowed, for instance? I mean, how often do people actually know that they can potentially get permission if they followed procedure?
Almost never.
Yeah.
I'd say the majority, 99% of home-based businesses,
Yeah.
whether it's the occupation or the home-based business, are done without seeking consent, either because owners don't know that there's a requirement to seek consent, or they just feel it's too onerous to get that consent.
Yeah. I think that's the important part there, what you're saying. It's a very onerous thing, and we've just seen there, written consent from all owners. I mean, that's a extremely onerous thing to achieve. Very, very onerous.
Yeah.
Prescribed management rule 30F, the body corporate must ensure sections are used according to their intended purpose. Excuse me. Yeah, so I mean, we're talking about sections here. We're not talking about exclusive use areas, for example, but do exclusive use areas come into play here as well? I mean, we look at
Yes.
exclusive use areas like parking bays. People, I'm sure this happens. Parking bays are enclosed, becomes a storage facility. Somebody runs a distribution business from there, and they've created a storage area from a parking bay, and they don't have the permission from the owners. I mean, I'm guessing that would be a good example or something like that.
Yeah. And in fact, Andrew's question is a good example of that as well. So just to start off that, clarifying, Section 13(1)(g) and Prescribed Management Rule 30F, both of which speak to each other, just by the way. So 30F is in support of 13(1)(g). It provides a bit more flesh to the bones that 13.1G sets out, and it refers to a change in use of a section or exclusive use area. So it applies to both, whether or
Okay.
not the exclusive use area is rule-based or registered.
Okay.
Just by the way.
Yeah.
So taking Andrew's question, so if a resident running a construction company and uses his garage in the complex to store all of his
Yeah.
equipment instead of storing his vehicles, that regardless of whether it's, let's take the business out of it, the fact that he's using a garage as a storeroom area triggers the requirements of
Yeah.
13.1G.
Yeah.
And therefore the written consent of all the owners is required for that, irrespective of the fact that it's for a business, linked to a business.
Yeah. And I'm asking this for the benefit of everybody. How do you, I mean, let's assume this has now been established. And obviously the trustees and the body corporate knows that application hasn't been made. There's no permission from all the owners or everything like that. How does a body corporate actually enforce the owner to comply, one, or two, stops them from doing what they're doing? Because I think that probably is even a bigger problem to actually deal with. I mean, yes, you can go to CSOS, but how do you actually impose the restriction, even though those rules are there, or those yeah.
Good question. And in fact, CSOS won't have jurisdiction over a situation like that if one were to look at the prayers for relief available under Section 39. I don't believe any of those prayers for relief comfortably fit
Apply, yeah.
this scenario, because you effectively, if someone had constructed something on a garage, for example, to make it into a living quarters, CSOS can't order a demolition order to revert it back to a garage. So you would need to approach the courts in these instances.
Right.
And there's a reference to a case at the bottom of that slide, Minio versus Bay Dunes Body Corporate. And then this is quite an interesting matter, and the principles are going to be quite important for this workshop. It's the applicant, Miss Minio, was actually a client of mine, and we assisted her with a scheme where there was a widespread issue in that scheme where owners had converted their garages into living quarters, because the garages were attached to the unit. It was all single story detached units throughout the scheme, and they thought it was quite useful to convert the garage either into a living space or into a games room or whatever. So they changed it from a garage into something else, and we took, on behalf of our client, we took objection to that, and the body corporate refused to act on it. The trustee said, well, what must we do about it? So we assisted with an application to the High Court and sought an order directing the conversion back to garages only. And the argument was that by using the garages for a purpose other than storing a vehicle has a knock-on effect on the scheme, because now people have to find someone else to park their cars. So there was a widespread issue with unlawful use of common property, just parking cars everywhere. So it has an adverse effect on the scheme. And the judge, in fact, agreed with that argument and found that, in his mind, the correct interpretation to be placed on Section 13.1G, read with 30F, is that where an owner intends to use a section, or in this instance, part of a section, because the garages were in fact included in one section, so they just changed part of the section, for any use other than its intended purpose, and this is the catch, and such use or intended use materially affects other owners in the scheme, then the consent of other owners, of all owners, is required. And in this instance, it obviously did materially affect other owners in the scheme, and therefore they were ordered to revert them all back to garages because they couldn't obtain the written consent of all owners.
I see, yeah. As a matter of interest, I mean, was that achieved? Did everybody actually convert their garages back to garages?
Yes.
Okay. Okay. Interesting.
Yeah.
And was there a time period? Was there a limit, in terms of how long they had to do that? Or
Um, sorry, the time period.
so, for instance,
Um,
after the court had ruled, were the people, the owners, given a certain period of time to convert that back to garages? If they, let's say, for instance, they were using it for,
I see.
as living quarters or something like that.
No, there was no time period.
Okay.
Um,
But they were ordered to reinstate it, basically.
yeah, because I've obviously simplified the matter for purposes of
Of
this
course, yes.
workshop, but it actually, the matter actually, um, what actually happened was that the body corporate was made aware of the situation by my client, and then they said, okay, we're going to quickly get a special resolution to condone the conversion. They
Mm.
said, we're just going to get a special resolution and approve the conversion to a garage, from a garage to something else. And we went to court to declare that special resolution null and void
Mm.
because they, in fact, needed the written consent of all owners.
All owners, yeah.
So then the court said, this decision is null and void. You need to go get the written consent of all owners, which they eventually couldn't do. So then they had to be reverted back to garages. So that's what happened off behind the scenes after the
Right.
court case.
Yeah. So that's where that comments at the just above the example court case, typically requires unanimous consent, and that's the difficult part, which we've seen at the top there, written consent from all owners. So very very difficult to get, but we're going to see how people can actually do that or achieve that in the next couple of slides.
Yeah.
So the municipal zoning bylaws. I mean that's always a reference that is made, when there's a discussion about this. So the general provisions is that residential zones are primarily for dwelling purposes. So that's obviously the use of the section, is for dwelling, for people to live in. Certain low packed home enterprise may be permitted under specific conditions. Um, Maybe just touch on that, or if you don't mind, the
Right.
under specific conditions. So just asking a simple question, the specific conditions in this case is where the municipal bylaws allow for certain low impact enterprise, right?
Yeah, so let's start by unpacking the basics around municipal zoning bylaws. And I believe that the majority, if not all of the attendees here today, are situated within the city of Cape Town's jurisdiction and perhaps outlying municipalities in the Western Cape. But here's the basics from a Western Cape, from a city of Cape Town municipal planning bylaw point of view. There are various uses permitted as of a right to different zonings. So single residential zoning, freestanding homes as we know it, have certain uses that are
Yeah.
as a right permitted to them. And then general residential, sorry, GR1, general residential one, which is typically most blocks of flats and sectional title schemes, they have their own uses. So these uses are broken up into three categories. There's the primary use, then there's the additional use rights, and then ancillary use rights. Primary uses are the dominant use of the property. So in a residential zoned GR1 property, obviously the primary use is a dwelling unit to live in. But then there are also additional use rights. These are rights which the particular zoning of the property permits without the consent of the city of Cape Town, provided that any conditions set out in the bylaws are met. So as long as you comply with those bylaws, you can actually access that additional use right. And then ancillary uses are connected to those two. And then apart from that, you get what's called consent uses, consent use rights. Those are rights that you, in fact, have to go and apply to the city of Cape Town for, get permission, and only then are you entitled to exercise it.
Mm.
So in that context, home occupation, which I'll define in a second, but home occupation is an additional use right in group housing schemes, so GR1, GR2, and GR3. So a home occupation, in terms of the bylaw, is defined as the practicing of any occupation, so that's the first one, or the conducting of any enterprise, that's the business side of it that we were talking about, from a dwelling unit, by one or more occupants who reside on the property. Okay, so you have a dwelling unit, in other words, a residential property in which one or more of the occupants conduct either an occupation or practice an occupation or conduct an enterprise. So now we're dealing with working from home and home business. Those are the two situations. So under the zoning rights applicable to this type of group housing schemes, the additional use right to conduct a home occupation scheme is subject to the following conditions. So as long as you tick these boxes, you can do it. So this is the condition. The owner shall obtain the written consent of the relevant owners association, in this instance being a body corporate, and the provisions of item 23 must also be complied with. And I'll get to item 23 in a second. But item 23 deals, you'll see when we go through what item 23 lists, this deals specifically with home businesses, whereas home occupations, so the working from home scenario, still qualifies as a home occupation, but isn't doesn't have to comply with item 23 because it won't by its nature, and you'll see why in a second. But both need consent from the body corporate. Now let's look at item 23. Item 23 that says that the following conditions shall apply where a portion of the property is used for purposes of a home occupation. And I'm going to rattle through these quickly, Leigh. I hope that's fine.
No, that's 100% go for it.
Okay. So the first one is that no home occupation shall include a noxious trade, a risk activity, and a whole bunch of other issues, but ultimately any activities that are likely to generate a public nuisance. And this includes things like panel beating, spray painting, welding works, things like that. Then only goods which have been produced or assembled in the home occupation may be sold from the property. No goods for sale shall be publicly displayed. So in other words, there's no external evidence. There should be no external evidence of the home occupation. So no signage, no advertising signs. No activity shall be carried out which constitute or are likely to constitute a source of public nuisance. And that to me is going to be the most important takeaway here. Importantly, off-street parking must be provided at a ratio of 1 parking bay per 25 square meters of the area used for the home occupation. And the total area for the home occupation shall not consist of more than 25% of the total floor space of the dwelling unit, or 50 square meters, whichever is the lesser. So the total amount you can use, we know, can't be more than 50 square meters, and therefore you need at least 2 parking bays, because there's 1 bay per 25 square meters.
Yeah.
The storage of all goods must be inside the dwelling unit, and that answers the question that Andrew asked. It has to be kept in the unit. You can't use other areas to store. And then the last 3, just bear with me. No more than 2 vehicles may be used in connection with the home occupation. That includes clients, customers, deliveries, what have you. And then it sets operating hours between 8 and 5:30 on weekdays, 8 to 1 on Saturdays, and no work on public holidays or Sundays. And then lastly, and we'll get to this slide, I think is one of them, is that the city may at any stage call for the cessation of the home occupation to minimize potential nuisance to surrounding neighbors. So you can see from these items that I've rattled off that all of them deal with some form of interaction with a third party or a staff member or a client, which is why these apply to home businesses. But you can still have a work from home scenario, which is a home occupation, but isn't subject to item 23. But in both instances, you need the body corporate's consent.
Yeah.
Okay. So when I think I don't want to get to body corporate consent unless it's relevant for this, unless it's under another slide, and I don't want to
Yeah, we're going to look at the permissible scenarios, and then consequence of non-compliance and steps to ensure compliance.
Okay, so let's perhaps look at permissible. Yeah, let's
Yeah,
go on to permissible
yeah,
scenarios then,
okay,
because that'll then deal with
yeah,
some of the consent. So then you need to ask yourself when and how is consent needed in these scenarios.
mm,
So we've looked at Section 13, 131G and Management Rule 30F, where it requires the written consent of all owners when the
yeah,
change of use is implemented. And we looked at the case law, which says that the correct interpretation of these provisions is that the written consent is required when the intended use will have a material effect on other owners in the scheme.
mm,
So we know that we obviously that running a work from home scenario won't have a material impact on the owners.
mm,
Okay, so 13(1)(g) and 30(f) don't apply, but it's still a home occupation.
mm,
And therefore, the consent of the body corporate is still required. But in that instance, it'll be the trustees' consent.
okay,
They are empowered to give that consent because it won't have a material impact on the owners. But the minute we start dealing with a home business, with all the issues that we've listed in item 23,
mm,
then that triggers 13(1)(g) because there might be a material effect on other owners in the scheme, and therefore written
yeah,
consent of all owners is required.
yeah. Yeah, I suppose I mean the parking issue is most relevant. I mean, we know that
Yes.
especially new developments. I mean, parking is they just about scrape through to have enough parking for the people that live there. Not even talking about visitors. So
Yeah.
that is obviously going to be quite a big. That will have a massive impact on the occupants or the residents owners. And if you don't comply with that, then you're probably not going to be successful.
Yeah, so parking is the one, and then any potential, that's the word, potential nuisance to surrounding neighbors is
Yeah,
the other.
yeah,
Um, and in both instances, that's going to be a difficult barrier to overcome for getting
yeah.
past that approval process.
And I guess going back to what we said earlier is hence probably why you find a lot more businesses from home that are not, let's call it
Mm.
illegal, that don't
Yes.
have the consent of the body corporate because, I mean, it's quite an onerous process to follow. And just looking at the zoning bylaws, um, to consider that and go through the process of getting all the owners or even the trustees for that matter. Trustees, as much as what the trustees are responsible for the management of the scheme or the affairs of the scheme, you can find the trustees not agreeing on the request.
Yeah, and that brings up Brad's question in the chat. I think it's relevant, so I'm going to just add it, Joe, is that he
Mm,
asked if running a business is condoned by one set of trustees and has been done for a while, can this be changed by a new set of trustees? And what is the remedies? And that's a relevant question for this point where we find ourselves. So I've raised it. If one board of trustees grants consent to working from home, obviously not to a home business because they can't prove that, but to the
yeah,
working from home scenario,
yeah,
and a new board of trustees is elected and they come and say, no, you're not allowed to work from home anymore, that withdrawal of consent cannot be arbitrarily done. They have to justify the withdrawal. They have to say, based on the scenarios of this instance, we are withdrawing consent because you are in fact now creating a public nuisance because I
mm,
don't know, you're talking too loud when you're consulting with clients on your
yeah,
Zoom computer. They can't arbitrarily withdraw it. So if they do that, if they do withdraw it without reasons, that's an issue you can take to CSOS to say that that resolution was unreasonably passed or adversely
yeah.
affects your rights. So there
Yeah,
are
because it's got
certainly
to do correct because it's got to do with the trustees and CSOs can make it a call on that.
correct.
Uh, Correct. Yeah, so that's quite an interesting scenario because I mean the um just maybe touch on this, Oren, is obviously a trustee resolution can be overturned by trustees.
Yes.
Um, but I mean in this case, they would need to use scenarios like you touched on where the person that's been given the right to run the consultancy or whatever they're doing where they've actually breached the conditions of allowing them to run their business from there. And on
That's
that basis,
exactly right.
they can agree, well, not agree, but certainly between the trustees agree that they're going to withdraw the permission given to that person.
Exactly right.
Yeah. Okay. All right. So zoning bylaws, very important to look at. So permissible scenarios, remote work, professional services. I think we kind of touched on that already, but remote work, working online without client visits or deliveries, no significant impact on the property or neighbors. We've touched on that already. And then professional service, consulting services with minimal client visits, and obviously compliance with municipal bylaws and body corporate rules, and the permission from, in this case, probably from the trustees, or where required, written consent from all the owners. Non-permissible, high traffic businesses, hair salons, car repairs, or any businesses attracting frequent visitors. We touched on that, security, people coming in and out.
Yeah, and those businesses that fall under that first point, or most of them at least, are expressly prohibited under the bylaws. So even
Yeah,
if you did get the written consent of all owners, it's still
yeah,
hair salons not so much, but car repairs and things like that, things that are likely to generate a public nuisance,
yeah,
um, won't be permitted under the bylaws as
yeah.
a additional use right.
And just obviously, I mean, you do get mixed use developments as well. So you can find a situation where the zoning for commercial or retail, commercial or residential may perhaps allow for car repairs.
That's a very, very relevant point you've raised.
Yeah.
Um, that's quite an interesting one. And it does vary from municipality to municipality, the way that they zone mixed use schemes.
Mm.
So in some municipalities, they can actually drill into each unit's specific zoning. But generally in Cape Town, as far as at least what I've come across, they only zone the earth upon which the scheme is erected. So if there is mixed scheme elements on this one earth, they will give the applicable zoning to encapsulate all the uses on that earth.
Okay.
So there's a lot of the schemes in the city centre, for example, that have
Mm.
at the bottom retail and commercial components and residential at the top. Those residential units are in fact zoned as commercial because they're all on the earth. So that's a very interesting scenario, and I think that most municipalities need to find a better way
Mm.
of issuing those zoning clarifications
Mm.
to effectively separate the different components in a scheme,
Yeah.
because it can become problematic when you slap one size fits all zoning to
Yeah.
include all the units.
No, 100%. I mean, I can imagine the chaos that might ensue. But I think wouldn't you, in for instance, your prescribed rules, find that there are permissible usages of sections based on the fact that there's retail and commercial and then residential? I mean, is that some way of potentially controlling the usage of those sections?
So, yeah, I think if I understand the question correctly, zoning isn't the only consideration when looking at a change of use, right? Zoning is
Mm.
one of many um, determining factors to check whether a use has been changed. So let's take this mixed use scenario, and in fact, I'll use a real life example in a scheme in the CBD where it's a mixed use scheme and somebody owned a retail space and they decided the retail isn't getting enough foot traffic, so they converted it into an apartment. They
Okay.
they totally gutted it, built a beautiful apartment and sold it on that basis. And then the trustees were like, "Whoa, wait a minute, you can't do that." And then we looked at the zoning because the zoning, particularly mixed use zoning, is obviously, you can imagine, quite wide ranging. You can
Mm.
do pretty much anything there. So they were entitled from a zoning point of view to change it from a retail to a residential, that they could do. But then we looked at, okay, let's look at prescribed management rule 30F in a bit more detail. It says there that an owner may not use a section or exclusive use area for a purpose other than its intended purpose, as shown expressly or by implication on the sectional plan. The sectional plan doesn't change, obviously, because that doesn't show what's inside the unit, so that didn't help us.
Mm.
Or on an approved building plan. Okay, that helped us because the building plan showed it as retail space and only had a few fixtures and fittings. So they've definitely changed from the building plan. Can be reasonably inferred from the applicable zoning laws. No, that didn't help us, so that we didn't use that. Or the last point is obvious from its construction, layout, and available amenities. Obviously, the available amenities prior to the conversion did not make allowance for a residential unit to be built there. So in all of those scenarios, we found two that helped us, the building plans and the available amenities, and we said, no, sorry, you in fact need the written consent of all owners to have made this conversion. So it's not just zoning bylaws. Just bear that shouldn't be a takeaway, attendees.
Okay. Yeah, it's an interesting thing looking at the plans because there have been scenarios certainly where I've been involved in where just looking at the section title plans doesn't really help
Yes.
identifying something, but then you start looking at the building plans and so I guess also with older buildings you probably have more issues because obviously sectional title is developed and taken off over the last 20, 30 years. So, plans and how the plans are presented and all those kind of things have certainly changed over time. So I'm guessing, and this is just a wild shot, that older buildings with plans may not actually help identifying what you've just identified in your situation.
Yeah. So in those instances, those plans are likely missing in any event.
Yeah.
So then you would only be able to rely on the last scenario, and it's obvious from its construction, layout, or available amenities.
Yeah.
But what's problematic with that is 9 times out of 10, the conversion has happened before you were aware of it. So when you get there, now it's already an apartment.
Yeah.
So you don't know what the hell was there before it was converted.
Yeah.
So it's difficult to say, no, this didn't have the available amenities. So you have to be alive to these issues as trustees.
I don't want to dwell on this too much, but I mean, you're talking about the amenities available. So because a lot of retail in buildings, not all of them obviously, but it depends on the development. But you do find that amenities like toilet facilities are actually common. So in other words, there's not toilet facilities within the premises at the time, but then they convert that to residential, and now suddenly you have to put amenities in there, like water points, toilet facilities, etc. And obviously now it becomes a renovation, and now you start looking at, well, where's your application to renovate, etc., etc. So I guess the problem actually just starts escalating for the
Exactly. Yeah. I mean, let's take this boardroom I'm sitting in. It's roughly the same size of that example that I was giving you about the retail space. In this area, this could be changed into a beautiful apartment, but there's no kitchen, there's no bathroom, there's no occupation certificate for a human occupation in this space. So all of those issues prevent this area from being converted without the consent of all owners.
Yeah. I think what's important here is the importance of the trustees, to be aware of what's going on in their building. Trustees, they need to be active in managing the scheme. So, obviously, things like, for instance, having a building manager or somebody on site will quickly alert the trustees of something going on, and they could quickly try and stop that or at least try and figure out what's going on. Like you say, before you open your eyes again, you've got a residential apartment in a retail space, and there's absolutely no applications, no permissions, nothing's been complied with.
Yeah, and on that note, I think it's important to ensure, where possible, that you retain records of all building plans, so that you have this on file, so you can consult it immediately when there's an issue. As opposed to trying to rely on getting it from council, because that's always a headache.
Yeah. or from the owner.
Oh, well, or from the owner. Even worse.
Yeah, unfortunately so. All right, so we've kind of touched on the other things, businesses causing nuisance. I think that's pretty obvious by now. And then non-compliance with zoning. Those were non-permissible scenarios. So whatever falls under those that don't comply with those ones.
Yeah.
So the consequence of non-compliance, legal actions, municipalities may issue notices, cease or unauthorized activities, and then potential for court orders requiring cessation of business operations. You mentioned the cessation earlier in the chat, but Oren, these are all things that the body corporate will have to institute, right? I mean, or do you report it to the municipality, and the municipality now is like, okay, we've got somebody that's crossed the line without our permission, so let's go and see what's going on, and from there the municipality will take further action, or is it purely from the body corporate side? I mean, where do you draw the line in terms of what the municipality's responsibility is versus that of the body corporate?
Yeah. So the role of the municipality depends entirely on the reporting to the municipality. So they will only act on a reported complaint to them. So the trustees, or even an owner for that matter, can report an issue to the municipality. So if the trustees aren't willing to do anything, an owner can decide, well, I'm not standing by idly. I'm going to report this to the municipality. You lodge your complaint, they'll send out an inspector, assess the situation, and then the process is painfully slow, though. That's just you need to be aware of. You'll get first the owner will get a letter to effectively cease and desist, and then if they don't comply, they'll send another letter, and they'll give 30 days in each notice, but they only follow up like 3 months or 6 months after each letter. So it's really a painful process, particularly City of Cape Town for that matter. There are different municipalities in the Western Cape which are far better than the City of Cape Town in that regard. But yes, ultimately the ball's in the city's court. But if the city doesn't play ball, you can lodge an application to court to effectively compel the city to do their job. So
Right.
and then the city will be liable for those legal fees. So that's one process. If you want the city to be the aggressor in the process, and to take the lead, or alternatively, yes, you can as a body corporate approach courts for a demolition order if there's been any unlawful changes or alterations from a structural point of view made to a unit, or to get a restraint effectively against this person from conducting a business.
Maybe just going straight to the bottom of that slide, strained relationships with neighbors due to disturbances. And in this case, I'm not mentioning it because of the disturbances. I'm mentioning it, the strained relationship, because the body corporate has now had to implement these actions against the owner because they did something irregular or illegal, and now the body corporate is having to force that owner to actually comply with what they should have complied with in the first place. I think we see this often, Oren, you even more than we do. The infighting that goes on when these kind of things take place.
I've literally been involved in a matter where one of the owners bit a trustee on the shoulder, physically attacked the trustee and bit her on her shoulder because of situations like that caused by these strained relationships. So it becomes incredibly unpleasant. There are protection orders put in place. I mean, it can escalate very quickly. There's heightened sense of emotions in community schemes. So the issues of non-compliance like this, particularly, have to be dealt with before it escalates to a point where people are being bit.
But sure, that's quite dramatic.
Yeah.
Right, let's quickly, before we go to the next slide, the financial implications, reclassification of property leading to higher rates and taxes. And in this case, the implication, or the impact would be on the entire scheme. And then fines imposed by the body corporate. but again, fines imposed by the body corporate would mean that the body corporate would need to have rules that where they can actually impose it.
Exactly right.
Yeah. Right. Steps to ensure compliance. Um, Review sectional title plan, consult the body corporate, check municipal bylaws, and limit the business impact. I think those are all, in summary, very all the issues that we really discussed. Determine the designated use of your unit. Seek written consent if planning to run a business. So we discussed you need to get written permission from all the owners, or at least from the trustees, depending on what kind of business you want to run. Check the municipal bylaws. Aaron went through that quite a bit with the Section 23. So there might be scenarios where it is permitted, but then you still need to revert back to the body corporate, and then the impact of the business, which I think is where people probably sometimes get it wrong, thinking that they're not going to have an impact. And I think to use an example, rules of nuisance and disturbance, you can't tell somebody what a nuisance disturbance is. Each person's got their own level of
Yes.
or their own threshold in terms of what's a nuisance to me and what is a disturbance to me. And that's the difficulty of living in a community scheme, is that you can't throw a blanket over a nuisance disturbance. Just tell people to not bother you because you're playing some kind of loud music at 1 o'clock in the morning, thinking that nobody else has come knocking on the door, and that's why it's not a nuisance or compliant, a nuisance or disturbance. So yeah, I think those are the most, I guess, the four items that needs to be taken away from this, and obviously getting the compliance. And I think, maybe just to emphasize, I think what we've discussed tonight is it's not that easy. Hence, having so many people that probably do it and they don't have permission.
And the reason it's not easy is a residential property is exactly that, right? It's people's homes.
Yeah.
They live there, they sleep there, they raise their children there. They didn't buy into an office building.
Yeah.
So that's why it doesn't fit squarely into that space.
Yeah. Yeah. 100%. I mean, I can't agree with you more on that. On the conclusion side, working from home is generally permissible if it doesn't alter the residential nature of the property. Running a business from home requires careful consideration of legal and community guidelines, and always consult relevant authorities and obtain necessary approvals to avoid legal complications. And I think on the back of, Oren joining us this evening, I think probably worthwhile consulting with, an attorney or somebody like that to help you with that application, because it certainly looks like rough waters. Just assuming that whatever you want to do is going to be easy to comply with. Just going to some of the questions. Oren, I know you've kept an eye on the.
There's only one unanswered question, and that is from Daryl.
So
So Aaron's made a statement, which we've touched on. So hopefully we've answered it. And then Daryl has a question that I haven't answered. So Daryl states that with the advent of grocery home deliveries like Checker 6060, the increase in traffic into a complex from this source is far greater than professional person receiving visits from clients. Comment, please. Yeah, so that is arguably true, but they stem from very different sources, right? So grocery deliveries are an external source, dropping off to various people, whereas a home business is one unit being visited continuously. But yes, the problem is the same. And a body corporate certainly needs to make rules regulating that situation and make those rules correctly. Don't do what happened in a case that I was involved in, where a scheme in Melville in Joburg wanted to address the situation of home deliveries via Mr. D and Checker 6060. The trustees simply passed a security protocol, as they framed it, a security protocol to say all deliveries have to be collected from the gate. And this was I think it was about a 13 floor building. So I had to carry down and go get the thing from the gate. And my client was an elderly person on a ventilator who lived on the 12th floor. And we are like, what the hell? They can't do that. That's effectively a conduct rule. You're affecting the conduct or regulating the conduct. So we said, do you have to pass this by a special resolution? Trustees said no. We took them to court. And the court, in fact, agreed that security protocol constitutes a conduct rule. They didn't get special resolution, and therefore it was declared null and void and set aside. So make the rules, but do it properly.
Yeah.
Is a long story short.
Yeah. No, I agree with that. And I think, for everybody, err on the side of caution, maybe consult with a specialist, something like Oran of the World, and make sure that the body corporates make the right decisions in the right manner. Obviously, there's still and we're not going to go into this now. There's also obviously getting those rules approved by CSOS, but that's maybe for another evening.
And Leigh, I think I'm surprised we got through this, and we are at 6:30 and we all need to run. So let's end it. But I'm just going to plant the seed for another session. I'm surprised we didn't receive any questions about short-term letting and whether or not that constitutes a business and how to go about regulating that. What do the bylaws say about that and all that fun stuff? So perhaps for a future session, if you haven't done one already, I suggest
we actually had one early in the year. But yeah, you're 100% right. I mean, the fact that it wasn't brought up, you're 100%, and it kind of slipped my mind as well. But a great point. I think you and I actually discussed on Friday before as we prepared for today. But yeah, thank you for that. I think it's probably something that we should revisit because it's certainly not going away. In fact, it's probably just becoming more and more of an issue.
It's an epidemic. Yeah.
Yeah, and bodies corporate need to apply their minds on how they can actually, let's call it, manage it, because you're not going to take it away. So. Oren, thank you very much for your time. It is 6:32 now. For everybody that joined us, I hope you found some value in this evening's session. The session is recorded, and we will circulate it to everybody that registered for this evening's session. Oren, thank you very much for your time and your input. It's always refreshing and interesting and valuable. So have a good evening, and for everybody else that joined, thank you so much. We hope to see you at the next session. Have a good evening.
Have a good evening, everyone. Thank you for your time. Cheers.
Thanks, Oren.